Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Severine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Welcome, dear listeners. This is podcast number 14 of our series. And before we get going, just a short word of thanks to Newcastle Law School, who are our kind sponsors for this one, as well as several others in the past. So this one is Four Seasons Healthcare. It's tends to be shortened to FSHC, Group Holdings Limited, and Glas, Glas Trust Corporation Limited. Mostly shortened, for those in the know, to FSHC, or indeed just Glas Trust, but it's a bit of a mouthful. This is Court of Appeal 2019. So going back a little bit, but we've selected this one because Westlaw marks it as significant in terms of guidance and therefore worth talking about. The topic is a sort of mystifying one that most students find mystifying, rectification, which is the court's power to correct documents. And of course, we are talking about contract law, so it's correction of the language used in a contractual document because of what's called a common mistake. That is a shared mistake, shared in common. Both of the parties have concluded in error that their final document actually reflected the bargain that they had reached. So this is a bit of equity law. Those students sort of a bit perplexed by that. It's not the common law, it's equity, which gives the court power, policing control, you might say, over what we might archaically refer to as unconscionability or unconscionable conduct. And it would be unconscionable to insist on an interpretation given to a contract which does not actually match with the concluded bargain. And a little bit of background, I suppose, because I expect Tim will talk about these principles because he's keen on principles. This also touches and concerns, one might say as a lawyer, a couple of the common law principles. So we've got a principle of equity, but we've also got to juggle 2 other principles, at least 2, I suppose, and they are coming to us from the common law. So the first one is freedom of contract. This idea that Lord Denning once famously said, courts don't correct bargains, they correct documents. In other words, the bargain is down to the parties. And you might say the parties are completely free to enter into an arrangement, a contract that's not really in their best interests. But that's the idea of freedom of contract. The second principle that comes to us from the common law is this idea of objectivity, which first-year students looking at contract law in the first term, they stumble across that quite early on. In other words, we don't ask the parties what they really meant. We look at the language that they used and we use the hat, if you like, of the objective, reasonable observer to try and work out what actually they have agreed. So that's the objectivity principle, and it comes right up against rectification and equity, where you have this sort of possible tension, I suppose, between the objectivity and subjectivity. Subjectivity meaning what you actually thought and meant. Objectivity meaning we don't care what you actually thought. We are looking back as an objective observer. So that's the background. And in this case, it's quite a sort of high-value commercial dispute, really. The parties had entered into a deed, a binding contract, whereby FSHC, Group Holdings, had provided security to Glas Trust Corporation. And that is actually what the intention was. But when one looked objectively at the language that they had drafted, it went beyond that. Not only had they provided security, but they'd also agreed to accept the responsibility or liability for a whole range of debts that were owed by other companies in their group. So that was over and above what subjectively everyone was thinking was the bargain. But that's what the language appeared to mean on an objective basis. So the central question or issue, you might say, is, okay, can this document be rectified, corrected in those circumstances? And both the first instance judge and the Court of Appeal had no difficulty really in saying this is not what objectively was intended by the parties, looking at the correspondence that had passed between their solicitors. That it went beyond what they had objectively shown to have agreed. But at the Court of Appeal level, there was an issue or question as to the test. That is, the test for rectification in this circumstance, is it wholly objective, which is really what the law seemed to suggest up to this point, or was it subjective? In other words, could one ask the parties what they truly intended? That is what was going on in their minds. And quite a strong Court of Appeal. I say strong because when one looks at the identities of the judges in this case, we've got Lord Justice Flo, Lord Justice Leggett, Lady Justice Rose. Two of those were, after this case, elevated to the Supreme Court. And it was also a unanimous judgment. So I suppose there are two reasons there why I would say this is a pretty strong judgment of the Court of Appeal, which is possibly shows why Westlaw, for example, and no doubt Lexis give this as significant. It's a little odd, I would say, to kick us off, whether Tim and Severine agree with this or have some other comments. It's a little odd because it wasn't strictly necessary to have looked at this test for the purposes of this appeal. This is the Court of Appeal not exactly going out on a limb, but taking it upon themselves to clarify what they thought the law was, or indeed ought to be. And I say clarify because if you look at the case decision, you will see that the law up to that point had been understood to be how it was explained by Lord Hoffman in Chartbrook and Persimmon Homes back in 2009. And that's House of Lords at that time, and an obiter dicta. Nevertheless, anything that comes out of Lord Hoffman is generally viewed as good value for money, as it were. And that was the thing that the test that we had been basing our understanding on. And he was saying that it's an objective test in those circumstances. So we've got a difference of view between obiter decision in 2009 of Lord Hoffman and now the Court of Appeal 10 years later, who say, no, in these circumstances, it's subjective. So with that in mind, I can now throw it across, as it were, to Tim and to Severine. Have the Court of Appeal got it right? Any interesting thoughts? What do you reckon?
Can I just sorry, that will mean a little bit of maybe further explanation on the fact, and so maybe, the students, so I'm talking to you both here. Do we need to say that, perhaps something, Maggie, you haven't said in the fact, which I think is quite important to understand this particular. In 2012, the FSHC had agreed to provide security, and then something was lost, and so in order to remedy that, then in 2016, for the because the assignment had not been executed, then two deeds were executed, and that's where the common mistake or the issue arose. I'm happy for people not to but I think that is important to see what the dispute was on. What do you think?
Yeah, I think it just really shows that possibly these documents were drafted in something of a hurry.
Well, I I don't know. So the way I understand the fact is that the 2012 agreement effectively had not been executed as it was meant because there was something missing.
Yes.
So in order to remedy that oversight,
Yes.
2 deeds were executed, and in order to provide the missing security. But that's where it was discovered, unless I got it wrong, that those 2 security agreements added obligation to FSHC, and so that's where FSHC asks rectification of those deeds, so that effectively the 2016 agreement simply puts the parties back into the execution and the performance of the 2012. And so that's where rectification comes in. They didn't want to have added obligation, and so for me that's quite important for the people who listen to understand why is rectification being claimed.
Yes, I think I said, if you remember, that the agreement, as when you look at it, went over and above what they had originally jointly intended. So the joint intention, whether it's in 2012 or subsequently, was merely to provide security. A charge or a mortgage over some corporate assets. But when you looked at the actual document and interpreted it as a court would do, the document went beyond that and provided an agreement to be responsible for debts. So that's a bit different. Well, it's a big difference. I think you're right. I think it was because they realised these documents were missing, and that the absence of these documents meant that the company was in breach of obligations as to the existence of the documents, and that would trigger all sorts of other horrible consequences. So I think this was probably done, I won't say in a panic, but somewhat hurriedly, and perhaps the checking and the scrutiny. It's very clear for us to be sort of wise after the event. But at the time, maybe in retrospect, the firms and solicitors involved might have said, well, I didn't actually look at it as carefully as perhaps I would have done if I'd had 3 weeks.
I think what they were saying was that 2 partners involved thought each other had checked. Each of the others checked the, and then basically blaming the poor junior associate there or whatever. That's but the partner signs it off, and he takes responsibility, or she takes responsibility. But yes, it had been delegated down, and I think it's just one of these things that happens in somewhat of a rush. I think from that we can.
Yeah, sorry, Maggie, I hadn't. I think it. For me, it took me a while to try to understand the whole case, what was being rectified. And when I finally got it, that's why I wrote down the 2012 and the 2016.
Yeah, well, I suppose that's a fair point, because students reading this, or anyone coming to this kind of like cold, you can get terribly bogged down in the detail, and then that you sort of lose sight of the principle. The principle itself is actually quite complex, I suppose.
Well, that's the interesting thing, isn't it? Because your question is basically in 2 parts. One is do you agree with the outcome of the case, and then basically 2, do we agree with the principles as it's been restated? The approach or the deviation from Lord Hoffman and Maggie. I'm quite interested here. You must be quite conflicted.
Well, you won't be surprised, will you? I agree with the end result, the outcome, but I'm a contrarian, I suppose, and I'm also a fan of Lord Hoffman to my grave. And I think there are some problems with the reasoning of the Court of Appeal in this case.
This is going to be a good one, isn't it?
I don't know if you...
I can tell already.
Do you want me to elaborate, or
shall we pick something out? Where's your
your
first? I mean, the objective. I think you summarised that already, so I don't think we need to go into much more detail. So this idea. Well, the one thing I might add is, of course, that Legat suggests there could be a hybrid approach somewhere in here. This is when he's reviewing all the other cases, isn't he? He says there could be a hybrid position in which objectivity comes in as a basis of evidence and subjectivity, so of the subjective position. So basically there's an objective assessment of the subjectivity, which was interesting. But basically the positions that we're arguing against
that's always so. That's always so. If by that he means we ask someone what they intended, but we sort of run a reality check over that, as it were, which is kind of like to sort of ask yourself, how likely is this to have genuinely been intended, given these people are sophisticated business people and act reasonably and all the rest of it. So there's sort of implicit objectivity in that when you sort of test the credibility, I suppose, of a view that is said to be subjectively held.
Well, then there's also the approach that you could take that you say, well, not just is it just a mistake that someone objectively held, but did they actually hold the mistake? In other words, again, a matter of more of evidence, I would say, than of a legal test. Is it a mistake? So I'm proving here objectively that there was a mistake, but I might not have actually had that mistake. I might not have actually subjectively held that mistake.
Well, I think we have to be careful about the objectivity idea. What is it that we are scrutinising through the lens of subjectivity or objectivity?
Oh, yeah, let's go there.
It's not the mistake. It's the intention, which is a bit different, isn't it? The mistake is that both parties thought the final document reflected their intentions that had previously been concluded and settled upon. And so it's the intentions that we are trying to judge. What was each party's intention at that prior point, as it were?
Yes. I think the common intention that I'm trying to look at the paragraph, the conclusion of Legat is 176, and when he makes the distinction between common mistake and then the second position. So the now they have clarified that the common intention is not based on an agreement, because we also have to untangle all that, whether we need a prior agreement or not. But this is the outward expression of the court. I just wanted to agree with you, Maggie.
Good God. Are you feeling unwell?
I know. You use the particular expression that, has been used by Legat, because for me,
I suppose it might be useful for students to just sort of just peel back to the very simple approach here, because
tool. Yes, as a pedagogical tool, I think that, again, as ever, this is brilliant, because it gives the context, it explains, the mistake and etc., and the distinction between rectification and how the judges construct contract, and so all these things. So I think there is an awful lot of untangling, and there is an awful lot to be done in this decision. And perhaps to go back to what you were saying, Maggie, as to whether the Court of Appeal here went off on a tangent or not. Well, in a way, as a pedagogical tool, that is a brilliant. They have solved a few problems and trying to put a few problems to bed, so to speak, with, again, raising the distinction between interpretation of contract and other tools by which the court can look at what the parties intend.
But the reasoning, there's still a bit of oddity about it, because if you look at it very simply, there are two forms of mistake that might be considered by any court looking at rectification. And the first one is common mistake, and that's this what we're talking about here. But through time, common mistake has become sort of developed away from the very simple or simpler case where you have a prior concluded binding contract, but then you have a subsequent document which tries to capture that agreement contract in a written form. Yes. And that's how common mistake and rectification got going, as it were. So you have a concluded agreement. Let's say, for sake of argument, it was purely oral, because that was the original simple form of this. And then the parties said, well, we better nail this down in writing. So we've got a permanent record. That's how things started. And so they did so. But when they were capturing the agreement that they had already made, a mistake was made. And that's why you can see in that very simple case that the law using equity probably has no difficulty in saying, well, we must correct the document because the document does not reflect the contract, albeit oral, that had previously been reached. But through time, common mistake became enlarged, as it were, so that, that Jocelyn case, if any student is looking this up, that gets mentioned in all of these cases, it got extended to the situation where you didn't necessarily have to have a prior concluded agreement, but you did have to have what the judges referred to as a settled common intention on this particular point. You see where I'm going with this?
Yes.
And then you have a written document which captures the agreement, as it were. So this is extending common mistake to the situation where there's no prior binding contract, but there is settled agreement. Now, yes. Lord Hoffman's line up to 2019, and therefore this case that we're looking at now, was that it would be strange or anomalous if we treat those two types of common mistake differently for the purposes of rectification, because they are merely the same thing, but procedurally have been reached in a different way. But it would be anomalous to treat them any differently. And I don't think, if you were looking carefully at Chartbrook and what he said later in Brit Oil, so if anyone's trying to trace all these flipping cases that discuss this, Brit Oil is the other major one, I don't think he was saying exclusively the evidence has to be objective. So a subjective evidence is certainly admissible, but I think what he was saying was where you have a settled agreement, although it's not enforceable as a contract, on a particular point, because the parties have agreed that was our settled intention, in order to understand what that intention was, you're naturally going to use the typical objectivity, the standard approach of English law, in order to understand what they had agreed. But the Court of Appeal here have taken this form of common mistake where there is no prior settled agreement, and I would use the word a bit harsh, I suppose, dislocated it away from where it actually sits, that is common mistake as an extension of a prior concluded contract, and shifted it into the other form of mistake where rectification is possible, and that is unilateral mistake, which is, now we're into the terrain of Tim, who's keen on such things. But unilateral mistake, and he'll tell me when I get this wrong, is really looking at subjective intention, because unilateral, only one party has made the mistake, but the other party knows, subjectively knows, that you've made this mistake, and unconscionably says nothing to take advantage of your stupidity, possibly. And that's so classic, therefore, for equity to say, whoa, hang on, this can't be right. But this is very happily in the area of subjectivity because of this knowledge of the mistake that the other party is making. And that's what makes it's quite different. So I think Lord Hoffman would say, but these are in two categories. And unilateral is about subjectivity, but a common mistake is not subjectivity is not inadmissible evidence, but the purest form of the test is objective. But now we have Court of Appeal 2019 saying, no, that's not right. It's a subjective test in this situation. And Lord Justice Leggett says he sees no anomaly in concluding in that way, but that's where I have a problem. So I don't know, you agree with Lord Justice Leggett? No anomaly, this is not a problem? What do you reckon?
I guess here there was no unilateral mistake on the fact. But
No.
So I can see, Maggie, that what you're saying, but in this particular case, it was not a unilateral mistake. It is the position of the Court of Appeal here is clear that in the test for rectification now post-Charbrook, which I guess is overruled here, so objectively, if there is a prior contract, and even if there is no contract, but the parties had what they call the common continuing intention. So that's why it cannot be unilateral. But I think what is important to be said here is that the first basis is done on the normal objective standards of interpretation, and the second one will be done bringing the equitable principle of against conscience and good faith. So I can see what you're saying, but here there is no unilateral mistake.
No, and yet the Court of Appeal are treating it really in an analogous situation.
Yes and no, because I think it is right to make the distinction when there is, and that's where perhaps I can see why, you call it going on a tangent, and Tim is quite quiet. Tim, you'll have to come here at some point.
I'm waiting. I'm right here.
Oh, you're waiting. You're waiting to pounce. But so, in a way here, I think what Leggett is trying to do is to, and I know you can't see me because it's bringing lots of threads to try to logically bring everything together. So for the first basis for rectification, when there is a prior contract, when he says that it's based on contract interpretation, based on normal objective standards of interpretation, that makes perfect sense. And I guess because there is no contract, even though the language, I can see what probably makes you feel a little uneasy, Maggie, that basis for granting rectification is the equitable doctrine that a party cannot, against conscience and good faith, be allowed to enforce the terms. So I can see where perhaps indeed here, they're using the language of as if there is a contract, but there is no written contract. But for me, it is a neat trick to try to understand the basis upon which rectification is going to sit upon.
What does Tim think? Because I have a problem.
We've covered a lot of ground there, haven't we? We've just raced through a whole load of stuff. So let me jump on the idea with unilateral mistake and the connection. I mean, our typical case of Hartog comes to mind, but we can. I mean, that's the typical unilateral mistake. But we're also thinking of kind of slip of the pen, right? That the person writes 3,000 when they're meant to write 300 or whatever, and the other party knows about it. So that's a kind of ex post facto knowledge. It's the person knows beforehand that the other is making a mistake, and then there's something, I'm going to say in bad faith here, that the other party is taking advantage of that. And so the court has very little difficulty in saying, right, okay, we need to correct that.
Yes, but just make the point there that it would naturally therefore be a subjective approach that needs to be taken.
Absolutely.
Because you're talking about what someone actually knew, so you're going to have to prove what they actually knew. So that's classic
subjectivity. We have discussed this, or should have known, right? The willful closing of the eyes, centrovincial.
Well, okay, but willful closing of eyes is viewed by the English common law as pretty much the same as knowing.
Yeah. Which marries up with some kind of objectivity there, right? We're assessing at least objectively whether the other party knew.
Well, I mean, criminal law uses it, other branches of law use it with no difficulty. It's the Nelsonian blind eye.
Yeah.
You did actually know, but you closed your mind to what was obvious to you. That's still subjectivity.
Yes, has to be.
Yes, it's you might say a reckless disregard. You know, but you closed your mind to it. That's still subjective, what's going on in your mind. Whereas if you're talking about negligence, for example, that's you should have known. If you'd been taking care, that's way, way down the hierarchy of knowledge. That is more about what's reasonable.
That's what a reasonable person would have known in your position.
Yeah.
But, well, in a position that was... Yeah. Okay. But my point there was that this subjective knowledge still occurred before the entering into the contract.
Yes.
Now, with our scenario here, what we have is a similar slip of the pen, right? They thought they were recording their agreement, and actually they made an error in doing so, right? And they wrote the wrong thing down.
Bit more than a slip of a pen, but...
Well, in this particular... yes, in FSHC. But we could imagine the scenario as being,
I can tell you what happened. They've used the wrong precedent document.
Oh, yeah, they went to the wrong database. They went to the right database, picked out the wrong...
No one scrutinised it sufficiently carefully, that's all.
But that knowledge... Okay, so there's no actual knowledge that the mistake occurred. I mean, both parties are unaware at this stage that, when they're signing the document, quite obviously that has happened. However, if there is a subjective intention on both parties, then the principle is still pretty much the same, which is now that the knowledge appears ex ante. So, previously was exposed. Anyway, afterwards, the party gets the knowledge, right? So after the agreement, the party is now in full knowledge that there was a mistake and subjectively knows that there was that mistake, there was that error. Had they picked up on it beforehand, we would have been in the same situation of subjective knowledge as we would in cases like Hartog or other cases. So the position of the other party, apart from the malicious taking advantage, isn't fundamentally different, right?
It's a question of evidence and how difficult it is to win a claim for rectification.
That's not the principle.
In practice,
now you're bringing in externalities, which I will agree with you on, which I'll also agree on this case, or with you on the Hoffman approach. If we take into account certain externalities, third parties, as in Rose and Prim, general certainty, that's Hobhouse in Olympic Pride, binding people to something they didn't really objectively agree to, then I agree, those are externalities, but that's different to the principle that we're looking at.
I'm not talking about externalities, as you put it, third parties and so forth. I'm just simply making the point now that the decision of the Court of Appeal here has made it harder to succeed in a claim for rectification. And you might say, well, that doesn't matter. But I would say it makes this disconnect between a claim for rectification on common mistake where there has been a prior binding contract and a situation of common mistake where there has been a settled prior intention but no binding contract. In that second category of case, it is much harder to succeed in a claim for rectification, but that does not seem to have been the intention of English law when it extended common mistake to the situation where there was a settled, concluded arrangement on a point but no binding contract.
Why is that based on evidence harder?
Because proving anything on a subjective test generally is much harder to win because you are having to prove what was going on in the head of the other party. That's pretty hard to prove because courts, if you think about it, are geared up to assess evidence which they can read, hear and evaluate for themselves using this sort of lens of objectivity, which is this reasonable observer. And you might actually say, what are we talking about here? When we talk about the reasonable observer, we're talking about the judge, because it's what he or she thinks must have been in the party's minds. That is much easier, certainly, to predict what's going to happen at trial, and therefore it's going to naturally filter. Lots of cases will fall by the wayside if you have a subjective test, because any barrister would say, well, this is going to be harder to prove because you're going to have to prove on what evidence we've got what the other side were thinking. It's pretty hard to prove what someone else is thinking. Do you see where I'm going with this?
But it wasn't particularly hard in this case because...
Not in this case,
they could
but
simply
remember...
show... And I think an objective would have been harder.
Not in this case. Well, no different is what the judges were saying. And remember, with our case law, our system of precedent, it's not really about the outcome in a particular case because we have guidance that will apply across the board. In this case, as I said in the intro, actually, it wouldn't have made any difference whether the test applied was objective or subjective. So you're quite right. The party would have succeeded under any of those two tests. But that may not be so for parties to come in the future. And they are now stuck with a subjective type test, having to prove what the other party was thinking. I think that's hard.
It's still based on the common continuing intention. So they will still have, as it said here, the outward expression of a court. So they will still, I know what you mean, but there are still some elements in writing that will be used in order to assess.
Well, I suppose in most cases, and the more sophisticated and commercial the case, the more that you're likely to have of that. Yes.
I'm not sure. I'm not convinced yet. I wonder. So if I can prove, so take this case for example, where they can prove that they had at one moment in time a subjective intention. And they can prove that they continued with that intention. Now, that can't be too hard because, internal memos, emails, whatever, you can, on your own part, that's fairly easy. Now, at some point, Legat then says, well, it's then whether you can basically rebut the presumption that at some moment in time, that intention transferred to the other party. Now, okay, I accept there's some objectivity in that, is there? Or it's
not really transferring. You're trying to show that mutually, at the same time, through these negotiations, up to the parties reached a settled point of agreement, and both parties, in their own minds, had that same settled conclusion. And Severine's point is that that alone is insufficient. You also have to show that was manifested. Crossing the line sometimes is a phrase that I think is used. In other words, something was written or said to the other party. So, yes, that is true.
But the judges make the point that that's not even required. If we're talking about purely subjective, then we can have that they're working in a certain industry. It doesn't have to be expressed by the parties.
Yes, I think Lord Justice Leggett kind of like says, well, there must be situations where the understanding is tacitly held. Yes. I think is what he's getting at. That's I think what you're thinking about now, Tim.
Yes.
So something about the particular marketplace, for example, or the particular type of business. All the parties involved in that sort of business always have that understanding. It's a shared assumption of the market. So that sort of reminds me, I don't know about you, of sort of that case that we have done a podcast on, the Wells and Devani one.
Yes,
of the estate agent's fee. It was sort of tacitly understood that if I sell your house for you, you'll pay me. Yeah.
Well,
I don't think Severine doesn't have as much trouble with this reasoning as I do. I don't know where you sit now, Tim.
I think well, we haven't actually got to the part that I have difficulties with on the purely objective approach yet.
Okay. Go on then.
We've got a long way to go.
Tell us what you have difficulty with. Where do you have difficulty?
So the first one I think I've mentioned in a different context, which was, we could have a mistake that's objectively held, which then turns out they don't actually hold that mistake, so subjectively don't hold. Another thing is if we're starting to align things with a mistake, we can often throw into the kind of formation category. we're having here a difficulty that we're moving away from the promisee objectivity, and we're accepting a third-party objectivity, which was actually rejected. Was it Denning, I think, who said, these are the three possible ways we can interpret, and then landed on promisee objectivity. Well, here we're now throwing that out the window, and we're saying, well, it's not about the promisee objectivity anymore. It's about the third-party objectivity. So we're introducing a different type of objectivity, even though
why is it third-party?
Because that's what the court says.
Yeah,
why? No. What do you mean third-party objectivity? What does that mean?
It's a reasonable bystander looking at what was said,
yes,
rather than promisee objectivity, a reasonable person receiving the promise.
But isn't that...
are they just talking about that because that's the natural approach when you are interpreting a contract? You stand back from either of the parties at that point.
Yeah, what would a reasonable, objective person...
Yeah, so I agree with Severine on that one.
So that's now we're moving on to my third issue. Very nice. So we take it there from the interpretation. We're moving then from the formation stage to the interpretation stage. So we're talking here about interpretation, construction of the document. Now, what I thought Séverine was going to pick up by now was in the mention in paragraph 146 of good faith. I thought we'd be on that by now, but I'll leave that for a moment.
You've had my views on, good faith. I think this is, it is...
Well, that's just to recognise that rectification comes from equity.
Right.
And equity is about policing. Conscionability is the old-fashioned word. A more modern phrase might well be good faith, but I think they are synonyms here in this particular setting.
Yes, I was still hoping Séverine was going to jump on that.
We can agree to disagree on that, whether they are, I think what is interesting for me is that, Legat is... Again, talking about good faith, and he's quite happy, is throwing good faith in when there is no contract, and so therefore he's bringing the equitable principle, whether that's one way of, for him to bring good faith through the back door. But yes, I was trying to think how I feel about it, because it's only mentioned in the same line as against good conscience and all that, and for me that is, again... reducing good faith to what we cannot do, as opposed to what positively it could do. But I guess that would be one way of, formally bringing in, and there are discussions, academic discussions. I right now I can't give you scholarly articles, but the question as to whether good faith is an equitable principle and fiduciary principles are the same, there is good discussion about it. So that's why I actually didn't want to go into the discussion of good faith, because I think it is not a minor point, but for me the decision is more important in trying to pull all the threads of where interpretation comes in, and and in the same way that we have had discussion of interpretation versus implication of terms as two different things, and so here I think maybe that's what he was trying to do here, to doctrinally and in terms of points of principle, trying to put things into categories which are reasonably clear, even though can clearly be linked by the fact that he also talks about policies, the reason why. I think that's also important. But so, yeah, that's my little point on good faith team. Sorry.
Do you know who always pulls the threads together?
Our sponsor.
Newcastle. Very good. Thank you, Maggie. There we are. Newcastle Law School.
I'm beginning to learn how to play this game. Our sponsor.
Very good. Newcastle Law School provides genuine research-led teaching so you can explore contemporary legal issues taught by experts in their field. Learn more about their International Commercial Law LLM or International and Global Challenges LLM by visiting ncl.ac.uk. Thank you, Newcastle Law School, for sponsoring
Yay,
us.
thank you.
Thank you.
So, skipping ahead, so that was at paragraph 146, and we'll come back to the good faith. I do find it interesting. It can't be a coincidence, of course, that Legat mentions good faith in the... I mean, it really can't. We can't
Yeah, I agree.
But
it can't be.
What I want to get at on the interpretation point is that now we're getting to the common sense element. Paragraph 190, I think he says. Well, it sounds like we're introducing this common sense, commercial common sense, looking as a third party at this document. Where that means that we're trying to move mistake really from the formation element to an interpretive device. And then I agree, then we can then we can jump into this should be purely an objective test. Putting aside the whole evidence element, and I do need to think more about your point, Maggie, about it being harder to prove the subjective part. But I'm really what I'm about, I think, with the objective subjective is what is doctrinally cleaner?
I think if you look at just on that point, I think if you look at Lord Justice Leggett, I think he's acknowledged that because he says, yes, it is harder to prove. I accept that, but it should be quite difficult to succeed. So he does acknowledge that at some point.
Quite, yes. I'm happy to go back on that one and to accept that. But I still think that the subjective approach is doctrinally the cleaner approach. Now, we have some difficulties, and that's what I was mentioning with the externalities earlier on, is that in certain circumstances, I think we have to accept that is not the only, I'm going to say it, value in competition here or in balance here. Rose and Pin, for example, were a great example in which we can accept that even though there might have been a mistake, and even though the parties had a shared understanding, and I think underlyingly even the judges accepted that, we couldn't change the bargain because it was part of a bigger picture, which comes back to the certainty point. And I'm wondering whether there it would have been just a bit more elegant to actually divide the test up and to accept that there's other elements within the law of mistake, the law of mistake and rectification, common mistake rectification, that need to be taken into account, which could impact any decision. Right? We can't rectify a document if others have relied on it.
Well, I suppose in fairness, but in fairness, no judgment will necessarily talk about the other factors that a claimant will have to show. If they're not live issues, then it's not necessary for the purposes of that judgment. So an effect, for example, on a third party might be a reason why a court exercising its discretionary power to rectify might refuse. So, one could acknowledge that rectification, given that it's rooted in equity, is rooted in court discretion, and there may be a number of factors that the court will have in mind. They just weren't relevant in this particular case, so I don't think anyone was banging on about them.
Point to make. So, doctrinally, then, the cleaner approach is either we're moving common mistake rectification towards interpretate as an interpretive device of the document, then fine, we can take an objective approach, or it's actually something that is more relevant to formation as a principle within it, in which case we need to be looking at the subjective approach. Now, the few issues is the fact that we've taken the objective approach leads us to this problem, right? Germany, for example, wouldn't have this kind of problem in the same way as, because they're largely committed to the subjective viewing, although then they have to get at it with remedies later on. So we're in this position because we generally take an objective approach. And I think that would be a justification if this is a corrective within the system for taking an purely objective approach to formation, then and interpretation for that matter, then we need that as a corrective, and then it should be subjective.
Well, we are English common law is more or less wedded to objectivity because of the strength of certainty and predictability, and it's going to take a radical shift to move English common law away from that, I would suggest. And Germany may have a different take on things, but that's supposedly or globally a strength of the English common law, that it is certain and predictable, all other things being equal. But at the same time, English law recognises that there are instances, and you use the word corrective, I think I could adopt that now, where correctively it's necessary to move away from that objectivity. And a rectification, for example, on the basis of unilateral mistake, I think is one of the best examples that we have of that. So
I'd like to note that Maggie is getting fairly dangerously close to almost agreeing with me. I'd like this noted in the calendar with a big cross.
Well, you know, my love, that I will agree on certain things, but it's not a universal. You can't assume that I will on all things. So that my only point of difficulty is putting this form of common mistake, splitting it away from the other form of common mistake and shoving it with unilateral mistake. That's where I have problems.
What makes you say it is shoving it with unilateral mistake? I think that's the point. Maybe my brain
because
is here, because here it was clearly accepted that both parties were under the same mistake. So.
Yeah, yes, but for common mistake in its classic form, which is you have a prior concluded contract, which you haven't reduced into writing.
Yeah.
You with me so far? But then you do put it into writing, and in that exercise of capturing it into writing, you make a mistake. Yeah. You make a cock up. Yeah. Something is written wrongly. Yeah. Something is left out. You use the wrong language. Those sorts of things. That is classic for the common mistake rectification, where a Court of Appeal in this case it accepts entirely that the test there for understanding what the agreement was that you then tried to capture into writing is an objective one in accordance with the normal kind of like English law take in terms of objectivity. But what they've done in this case is to say, but where you don't have a prior concluded contract, something binding and enforceable that you could go through a court, but you do have a settled arrangement and agreement on this particular point, that's different. And that is more like unilateral mistake, which is why I'm saying that they've pulled this form of common mistake away from the other form of common mistake and doctrinally, if that's the phrase, aligned it with unilateral mistake. Unilateral mistake, we're all agreed, the test is essentially subjective. You knew that I'd made a mistake, you knew what was in my tiny mind, and you knew that I'd made a mistake. That's classic for subjective tests, but they've pulled this form of common mistake away from, I would say, its roots and thrust it somewhere else. That's what I'm having trouble with.
So the reason why I'm convinced by this decision, it's by a spectrum here. Here, what the Court of Appeal for me tried to do is to cover so that the distinction between the first and the second basis for rectification, as it turns out, is highlighted here in this particular case, is quite fine. And for me, where I disagree with you, Maggie, in relation to pulling it towards the unilateral mistake, it's because even if the test is different, because in the first basis, when there is a prior contract, it's based on contract interpretation, and for the second, it's based on the equitable principle of good faith, then the Court of Appeal still makes it clear that even if there is nothing reduced in writing, there is still this common continuing intention. So the outward expression of an accord. So it's still based, again, looking at it objectively. What would the objective person, the reasonable observer, which I think here means nothing more than replacing the reasonable man. So the hypothetical observer here. So it's still pulling in the fact that yes, they might not have actually entered into writing, but there is an agreement.
Well, then you've got another problem, haven't you? You've got a problem now with the relationship between that point of law that previously we all thought we needed, this sort of manifest intention, the crossing the line point. Now, how does that sit with the Court of Appeal here saying, well, the test is fundamentally subjective? We've got a sort of, not exactly a jarring, but someone will have to work out in later cases how those two facets, as it were, or two requirements actually sit wholly together. It's a bit of an uncomfortable fit, I think.
The common continuing intention, to use the expression of the court, can still be, what was, for me, was the next step that a contract was going to be entered into writing. I think that's how I understand it. So based on everything that we can objectively assess, that's the common continuing intention.
Well, no, I think that the manifest idea of your intention is to get over that. What this is really getting at its nub is that whatever your intentions were individually as one of the parties, that in itself won't do. It's insufficient for the law because there has to be something by which we can see and observe, as it were. So there has to be that phrase of crossing the line. There has to be something which you've shared outwardly with the other party as to your intentions, because otherwise anyone could say anything was their intention.
And therefore that's why it is a common mistake. It's still a common mistake and not a unilateral one.
Well, the point of distinction really is the knowledge or the lack of knowledge of the error that's being made by the other party. That's what makes the difference. If it's common mistake, then both parties are labouring under the same misapprehension, as it were. It's not a situation where one party knows the truth, if you like, knows the true position and also knows that the other guy's making this mistake. That's unilateral. With common mistake, you're both innocently, as it were, if I use that word for a minute, entirely in good faith, if I use that word that you like, or that phrase that you like, proceeding on the same basis. So it doesn't have anything like the sort of unconscionability tones around it, as it were. The only area where you can see that there's unconscionability is, I think, a point that Lord Hoffman made in way back when he's saying, well, there would be some unconscionability where the party, even in common mistake, where the party is resisting a claim for rectification. It's at a later point, to take Tim's idea of timing. It's at a much later point when you're in a dispute in a court, as it were. But there's still at that later point the prospect of some unconscionability. You have legal advice. You knew what you were doing, and you are resisting in an expensive fashion. You're calling someone to take all these court proceedings and make the claim good. So that could be unconscionable, but it's a much later point in time.
That shouldn't really matter, right? The mischief is still the same.
No, okay, but I'm trying to see where the points of differences are between these different forms of mistake. I accept entirely there can be unconscionability in all of the forms, but it's happening at a different moment in time in the relationship, if I put it that way.
I would tend to agree. I'm still not quite sure we know exactly where we disagree on in the detail, except that we come to different conclusions, which is fascinating.
Yes.
I think what we're saying is, so Maggie said it a lot better than I could, is basically I'm saying we're trying to fix the same thing as with unilateral mistake, and therefore the subjectivity is actually justified. Maggie is saying if we look at the historically what we're trying to fix, as it were, then as a matter of continuity, objectivity is actually the better route to go down to, or the cleaner route, as it were, to go down.
But my point is that it does not make evidence of subjective intention inadmissible. So in a sense, we're sort of all of these cases are getting the terminology, we're sort of seizing on it. And I think, with respect, that's what Lord Hoffman has been misunderstood on. I don't think he was saying evidence of subjective intention is not admissible. It's simply that when you are trying to interpret what a settled intention was, you would naturally, as English court, be viewing it through the lens of objectivity. It's not what you thought it meant, it's what it seems to mean using an objective interpretive approach, which is standard for English common law. Maybe different in Germany and so forth, but that's the natural way we interpret agreements. We view them objectively, their meaning. So he's saying subjective evidence is fine up to a point. It's not ruled out, but it's not the way in which you interpret the language which is used in any contractual setting. At that point, if you've got a settled agreement or you have a binding contract, you would naturally be interpreting the language objectively.
Doesn't he rely on heavily on the quote by Denning saying something along the lines of we only consider contracts and documents, not intentions? I mean, that sounds to me like he's saying no, subjective intentions are not relevant.
No, I think he's trying to make the point that I'm trying to explain, and not as elegantly as Lord Denning ever would have done. But I think that simply to acknowledge that when we are interpreting the language used in a contract, and extend that out now because of the development of the law of rectification to a situation where we might not have a binding contract, but we do have a settled agreement on a particular point, to understand the meaning, aka interpretation or construction of that, we apply an objective approach. And so Lord Denning would say, it's not for an English court to make a contract. That is for the parties to make it. Our job is to find the meaning of the language that they have used. Does that address what you have in mind? There's a pregnant pause of deep and profound thought.
I think that's exactly what this case represents. So you would be happy then to say, well, our basic approach, and you will have to correct me on this, the basic approach is objective. We're taking a third-party interpretive approach, or actually we should probably call it construction, of the clause or the contract or whatever that needs correcting, or that should need correcting. But if you can show objectively that subjectively the parties held certain intentions, then that's okay.
There's too many ivities in that.
As well? There's too many. Was it Paul Davies, I think, who said there's too many subjective objectivities around.
There's too many.
Is that.
You have to show subjectively, that's what was through the parties' mind, that they thought they had reached a concluded, settled arrangement on this particular point. I accept entirely that particular question can only be resolved with the subjective test. That is, had you reached a concluded, settled arrangement on this particular point? And yes, you'll be testing what their response is through a sort of lens of objectivity by asking yourself, well, how reasonable is that assertion, as it were? And therefore, does it look like it was genuinely held? So if both parties are saying, yes, we concluded that particular point on, say, Tuesday the 12th of March, whatever it is, whatever were transferred between us on that day, that was our concluded arrangement. We didn't come back to that point subsequently. Now, I think all of that is essentially a subjective test, if you have to give the flipping label to what's going on here.
And at the moment, still closer to Legatt's test than Hoffman's.
Well, only on that. That's why I've said a number of times, I think now, Lord Hoffman is not saying subjective evidence is inadmissible. I don't think he's ever said that. But what he has said is that, okay, once you get to that point and both parties are saying on Tuesday, the 12th of March, what we transferred to one another by email represents our concluded position, agreement on that particular point, then at this next stage, we now, wearing our objectivity lawyer-like hat, look at what has passed between them and ask ourselves, and what the hell does that actually mean? That, I think, is my basic point. And I know you weren't happy with me going on about evidence, Tim, but at root, this is kind of like about how you prove these things. I know, you would say, well, you're a scholar and an academic, you're not so bothered about that. But I can see that this is really what the parties are arguing about.
Yeah. No, I'd agree. I think evidence is a big part of this. Absolutely. As you've said, we can still commit to a subjective test without destroying the need for a certain objective element within it. I think, to me, the biggest question was, and this is the alignment with unilateral mistake, of course, as well, is are we fundamentally worried about the subjective intention of the parties, and we're trying to find the evidence for that, or are we actually aligning ourselves with construction and saying the entire thing is objective, and if you can't prove it objectively, Rose and Pym type scenario, then tough. And this is the complete removal, as it were, from common mistake away from unilateral mistake. And I think that to me was a defining part. And there I think, because I think the mischief is the same that we're trying to solve, we are closer to unilateral mistake than we are to construction.
Yes.
But I don't think we're far. I don't think we're far away from it.
So I think the problem that potentially we have is, what is it that they mean by subjective? So actually, I think, Tim, by talking about the mischief that indeed is attempted to be corrected, for me, and I think I agree with you, we're probably not that far apart. What is it that the court is trying to do here is to say, okay, so first base, there is a contract, therefore we can easily put that into the category of contract interpretation. Second category, there is no contract, so therefore we can't look at it through the normal contract interpretation because there is no contract. So therefore, I think what you've said, the mischief, what is it? So here, both situation, one, there is a contract, two, there is no contract, therefore we can't use the same basis, but ultimately you are right.
Yes, but that's the point of difference between us, isn't it? That is the nub of it. That's why you are aligning yourself behind the Court of Appeal and why I'm out on a limb here, because to my mind, the situation of common mistake where there is a settled arrangement on a point but no binding contract at that point is closer to where it came from in terms of genesis. That is common mistake where there is a settled concluded contract. And that Jocelyn case that actually developed the law was part of common mistake where there is a prior concluded contract. And so what the Court of Appeal now has done has ripped that away from its housing point, as it were, from its genesis, where it came from, and said, no, as you're saying now, Severine, it's about unconscionability or good faith, because there was no concluded contract, and nevertheless you've got people behaving badly. And so this is more like unilateral mistake. That's the point of difference between us, I think.
What a wonderful summary. And I think we've actually managed to crack our record on longest recorded podcast so far. So on that summary, I think we might finish there, unless, Severine, you have some profound insight to it. No.
I think it was beautifully said.
I think so too.
So, yeah.
So we'll all agree that Maggie put it very nicely. And then we can shirk.
Yeah, at least we know what we're disagreeing on, eh?
It's only taken us an hour and 10 minutes or whatever to work that out.
Wow.
What does that say about us? Well, if you have something to say about us, dear listener, then do get in touch at unpacking.contract.law@gmail.com. We'd love to hear from you. And on that note,
Thank you. Bye-bye.
Thank you very much and goodbye.